Good morning and welcome to an informative webinar presented by CAGC, the Chicagoland Associated General Contractors. As most of you know, we represent commercial construction here in the Chicagoland region. Our 220 members represent over 10,000 employees and over $12 billion in economic activity annually. I am your host, Tom Kukelich, the Executive Director of CAGC. On behalf of your CAGC team, Stacy, Emily, and Mike, we are glad you have joined us. We have all been working hard to bring you the best, most relevant, most vetted information during this COVID-19 crisis. And while our industry is essential and has continued to work while providing safe environments for construction, most of the challenges we have faced have come about quickly. It has been our ability to respond to these challenges that has allowed us to remain successful in these trying times. The latest such challenge has been the snap of the fingers change to our workers' comp process, and that is what we'll discuss today. This has been our highest priority, and we have been intensely lobbying the governor, the General Assembly, and the Illinois Workers' Comp Commission since it was so quickly announced. This webinar will focus on your frequently asked workers' compensation questions affecting our industry. We will gain more insight on how changes to the Illinois Workers' Comp rule affect contractors, how to proceed when an employee claims a COVID infection through work, and how to proceed with worker comp claims that are not COVID-19 related. We are honored to have two of our own members here today to handle this topic. Jim McInerney from Gallagher, who will be our moderator, and Rich Lenkoff from Bryce, Downey & Lenkoff, who is our expert presenter. I will take care of both introductions now, then get out of the way for Jim and Rich. Jim McInerney is the Area Senior Vice President in Gallagher's construction practice. He is an industry expert with over 2 decades of construction and safety experience. In Jim's previous roles, he has led teams who have built some of the largest, most complex buildings in the Chicagoland area, including Gallagher's own headquarters. Jim works on the creation and negotiation of the insurance sections of construction contracts, contractual risk transfer requirements to subcontractors, and overseeing the overall insurance and risk management program for large contractor clients and prospective clients. His focus is on optimizing construction clients' insurance programs to enhance their overall profitability. With his extensive industry expertise and impressive background, Jim is a leader not only in Chicago, but nationwide. Rich Lenkoff is a capital member of Bryce, Downey & Lenkoff. Rich brings a killer instinct and an unparalleled focus to representing his clients. He partners closely with Fortune 50 corporations and small businesses to achieve successful litigation outcomes. Some of Rich's recent accomplishments include being elected to the 2020 Illinois Super Lawyer List, named a leading lawyer, and honored by SEAK as one of the 50 most influential people in workers' compensation. Rich has received the top score from Target Corporation's nationwide panel for general liability attorneys. In May 2017, Target named him their Bullseye Barrister for outstanding jury trial and other results. He is a frequent lecturer and involved in a number of national organizations, including Claims and Litigation Management Alliance, Illinois Association of Defense Trial Counsel, and the Illinois Retail Merchants Association. Rich co-hosts the nation's premier legal radio show, Legal Face-Off, on WGN Radio, which covers legal stories from politics, current events, entertainment, and sports. He also is the co-founder of Chilla Productions and a prolific producer, having produced 85, the greatest team in football history, a documentary about the 1985 Chicago Bears, which you can see right behind him. With that said, I'll get out of Jim and Rich's way. Take it away, guys.
Thank you. Hey, we appreciate you spending some time with us today. At Gallagher, we partner with contractors to address your 6 cost drivers of your risk management program. Our model is designed to drive down your total cost of risk and improve your balance sheet. Throughout COVID pandemic, it has been our goal to be at the forefront of all new legislation and potential coverage issues. We've also been helping our clients with their cash flow concerns and legal questions by engaging our network of financial and legal professionals. Our speaker today, Rich, is one of those professionals, a leader in the work comp arena and specifically within the construction industry. The goal of today's webinar is to help you better understand where you stand with the constantly changing work comp rules and some strategies to minimize your risk. With that, if everybody can keep their phones on mute or your laptops on mute, you can put questions in the chat box and we will address questions at the end. I know Rich has got about 30 minutes to really tackle this topic. And so with that, I would like to introduce Mr. Rich Lenkoff.
Thank you, Jim, so much. And thank you, Tom, and Tom's excellent staff. Stacy and Emily have been really great in putting this presentation together. We, as Tom and Jim mentioned, have worked with contractors and the CAGC for many years. We represent lots of employers in this area, construction, contractors. We also do a lot of work in the construction defect and personal injury area on the side of construction. So very honored to be here this morning and share some thoughts. Obviously, as both Jim and Tom mentioned, the issue is changing rapidly. It's funny because yesterday we went through some of what we're going to cover today, and almost immediately after we were done, I jumped on a conference call with the chairman of the commission, and everything changed. So we'll tell you how things have changed and what you need to do going forward when you've got COVID claims. We've got there's a newsletter, by the way, that we do. We'll send it out to you if you're not already on our list. We've got a poll to start off our webinar today to sort of set the framework. We know a lot of you handle workers' compensation claims in one way or the other. So we're going to ask you some questions based on a short hypothetical, give you a chance to weigh in, and then we'll talk about some of the answers, and we'll jump into the COVID issues. Jim, do you want to take over?
Sure. So here's our first poll. We'll have two polls here. So the first question is, if we could pull this up, your electrician employee tests positive for COVID-19. He lives with his sister, an ER nurse. He hired an attorney and filed an application with the IWCC. Do you, A, accept he's an electrician?
And by the way, when we say
B,
accept, Jim, when we say accept, we mean accept the claim or deny it, right? All right, go ahead, sorry.
B, accept he hired an attorney. C, accept fighting it is too costly. D, deny he lives with a nurse. And E, deny he hasn't proven his case yet. So we're going to open up the polling right here, and we're going to allow you about 30 seconds to dive in there, and we'll give you some of the poll results back within 30 seconds here, and then we can do a little mini Q&A, and then we'll move forward with the presentation. So it looks like most people are asserting deny he has not proven his case, E, and so that seems to be the most common response to that. Rich, you want to build on that particular point?
Yeah, I don't see the results. Can you tell me the percentages for the rest? Do you have those, or?
Let's see if I'll let Emily kind of calculate that up. 80% says E. Interesting enough.
Wow, really interesting. I actually thought, I'm surprised by that. And I thought that we'd have more sort of disparate answers because, they all are sort of, I think, tempting. Does anyone in the Q&A box want to explain why they said E or why they said some other answers? Again, we haven't revealed what we think the answer is yet, so 80% of you could very well be wrong for all we know. So does anyone want to explain how you came up with your answer? All right. While you're typing those in, I will tell you that most of you are correct. The answer is, in fact, E. Okay. And the reason I thought I'm surprised by that is because, given all we've heard about the rule change and the national attention the rule change has received, the perception has been that these cases are very easy to prove. Now, this is an up to the minute question, and the reason it's E is because that rule, as I mentioned, is now gone. It's been rescinded by the commission. So we revert back to where we were a week and a half or so ago, which is that it is the employee's burden to prove all elements of their cause of action in a workers' compensation case. So the answer is E. He hasn't proven his case. Now, there are some tempting answers, right? He's an electrician. Well, an electrician was a covered employee before yesterday and before the court entered a temporary restraining order on Friday. So before Friday, that might have been a good answer. B, you should accept the claim. And I realize, by the way, that a lot of you attending are not the ones who make the decision as to whether to accept or deny. I get it. Certainly, I think you have some input, though. So he hired an attorney. Does that matter? Probably not. I'll explain why in a moment. Not many of you said you should accept it because fighting it is too costly. To me, that's the most interesting answer. And it, obviously, less than 20% of you came up with that. That, I think, is an answer that many clients, many employers are looking at. So I'm actually glad, not because I want you to fight cases, but because I think legitimately these are hard cases to prove. So I'm glad that your initial instinct is not, let's just pay it. It's too costly to fight. It's easier to just pay and move on. And we'll talk about the reasons why that's not the greatest idea, in my opinion, in a moment. And then finally, deny, he lives with a nurse. That's obviously a factor that you would look at as to how he developed COVID-19, right? That would be an indication that he didn't develop the virus from his work as an electrician, but rather from his exposure to someone in his home who may have gotten it somewhere else. So congratulations, you're all on the ball. Many of you got the right answer. So let's jump into what happens when you've got someone who is your employee and they allege that they developed COVID-19 from work. What do you do? How do you deal with it? There's four main things you need to be concerned about. Okay, the first one is diagnosis. Just this morning, I was watching on CNN and they had an expert talk about how the symptoms, again, we've all heard this, but they reiterated just as recently as this morning, how the symptoms of COVID-19 parallel many other conditions. So your first question is, does your employee who's alleging an illness actually have COVID? Have they been tested? Have they tested positive for COVID? If not, then it doesn't mean that you don't have a claim. Doesn't mean they can file a claim for, the flu or the cold, but those are obviously much more difficult cases to prove, right? If COVID is difficult to prove, as we'll talk about, the ability to show that you got the flu from work or a cold or the sniffles or headaches is almost impossible. So if it's not COVID, then, you could deny it almost every single time. Assuming you have a legitimate COVID case, diagnosed, tested, the key question is number two, accident. And this is what everything that you've heard about for the last week, hopefully some of you have looked at our updates. I know Jim has done a great job updating everyone as well. From our updates, you will know that this is the main issue that the commission has been dealing with over the last week and a half. So I'll go into a little bit of that, understanding that it's all moot because, the rule has been rescinded. But I think it's important to know the context of what we've been dealing with. And this all comes down to the burden of proof that an employee who is alleging COVID, who has COVID, has in showing that the COVID arose from work. So most of you know that you can't just say, well, I have a condition, I work for my employer, therefore the two are related, right? You've got a burden to prove as a petitioner, as a plaintiff, as someone bringing litigation by a preponderance of the evidence, meaning more likely than not that work was the cause of your condition. So, you probably heard the term increased risk. The petitioner has the burden to prove that they have an increased risk versus everyone else in society. So traditionally, that's a burden that petitioner has, and if they don't prove it, then the employer wins when it comes to litigating these cases. Well, the commission decided to change that rule, as most of you have heard, and make COVID a specific class of injuries. That means that if you're in the group of employees enumerated by the rule change, and that list was huge, then you don't have to prove the same thing you did before. You get the benefit of an assumption, of a presumption actually, that your COVID is related to work, because the commission felt that this was an emergency. They wanted to take care of employees, and with certain employees, they didn't think it was fair to make them jump through all these hoops to prove COVID. So they created a rule change and said that if you're in the enumerated group, which includes first responders, nurses, all the people you traditionally would think of, but also, and here's the kicker, a huge list of employees. I mean, contractors, motel workers, gas station employees, even, in my opinion, a list as preposterous as teachers. And the teachers specifically say in the rule change, this includes teachers who are practicing distance learning. So just think for a second that, the commission in their wisdom decided that if you're a teacher sitting at home on your computer all day teaching, which, listen, I love teachers. It's an incredibly important profession. But people who are sitting at their desk can't imagine how they would develop COVID from being a teacher. So that list was long, and it greatly expanded the ability to prove COVID. And very importantly, the way it was put in place was outside the legislative process, not much due process, not much buy-in by the employer side, done very quickly. The IMA and IRMA, both of whom led the litigation, I've been longtime members of both, work closely with both, said that they were in a meeting with the chairman on a Friday, and he said they weren't going to do anything. And then this came out a few days later. So, all of the employer groups, including, the good ones that we're dealing with today, were involved in protesting against this because they weren't involved in the process. The commission called it not substantive changes, but rule changes. They tried to say, well, this is not really a substantive change to the law, therefore we don't have to go through the legislature. That wasn't true in my opinion. That this was incredibly substantive, change, maybe the most substantive change in the last decade at least. So that resulted in a lawsuit that was filed by the Illinois Manufacturers Association and the Illinois Retail Merchants Association, along with many, many groups, including, groups like CAGC were lobbying very hard to overturn this. So last week in Sangamon County, which is downstate, much more conservative than, some of the northern parts of Chicago, or Illinois, I should say, a judge signed a temporary restraining order saying the commission cannot enforce this rule change, saying that it went outside the legislative process, it was illegal, it wasn't consistent with due process, and immediately the commission cannot enforce those rules. So that was a good development. We were all very happy, but the court said that the defendants, the commission and the chairman have a chance to rebut it, have a chance to file a brief, and also he set oral arguments on the issue for May. So it was a good sign, but this was temporary. And of course, the defendants had their due process rights to fight it. So all of a sudden, yesterday, literally, I think, Jim and Tom and I got off the phone at about 9:30, and I jumped right on a conference call with the chairman of the commission saying, oh, we were just kidding. Forget everything. It was kind of like the, who remembers the Dallas season with Bobby Ewing, where he was in the shower at the end, and he said the whole season was just a dream. The chairman said basically, everything we've been working on and slaving on for the last week and a half, forget it. It's now nullified. Listen, no disrespect to the chairman. He's a great guy. I think he does a great job, as do the commissioners who voted. The chairman said, listen, in light of what the judge said, this is it'll take too long, too expensive to litigate. So we are formally rescinding the rule, effective immediately. He did say that the commission is going to form a committee of practitioners and other stakeholders to decide how to deal with the issue going forward. So as of yesterday at about 10:15, that whole rule change that we talked about, that going into yesterday, this PowerPoint was going to focus on, is no longer at issue. So that is a very good development for Illinois employers. I didn't see the exact numbers, but the cost to insure the claims that the rule change would have covered would have been astronomical. I mean, certainly in the tens of billions, not what carriers envisioned when they wrote policies. Myself as a small business owner who has a workers' compensation policy, I shudder to think of what effect it would have on my policy, to realize suddenly that this policy that we bought would have to cover, a whole class of employees and have this standard of proof that wasn't envisioned. So forgive my long history, but I think it's very important to realize, what happened over the last week, and especially what happened yesterday. So back to our point. Accident is now back to where it was a couple of weeks ago, and where it has been for 100 years, which is that a COVID employee is treated the same way as any other employee. They have the burden of proof to prove that their condition arose out of and in the course of their employment. Now, how are they going to prove that? It's almost impossible, in my opinion. Again, until they change things again, I think that they will. I don't think that Pritzker, our governor, just is going to give up the issue, although I saw him on the press conference yesterday. He didn't really address the issue very much. He was asked, and he said, we're going to look at it. I think Pritzker will put into place an executive order, much the way some other governors have done, that will fix the issue about going around the legislature. He has the power to do so through an executive order. Second choice is going through the legislature. Many of you know, who are here in Illinois, most of you are, that our legislature is covered, or is Democratic on both sides. We've got a Democratic governor, so it wouldn't take very long to jam this through. The third option is making some changes to a smaller group of employees, like first responders, through this committee. I don't think it's the end of the issue, but today, and things might change, in a few hours, but today, these cases are ones that I think you should deny for the most part, because practically, even if you got an employee who's, out there working, who's exposed to the world, it's very difficult to prove that you developed COVID as a result of work. Now, literally yesterday, I got a case from a client, and the fact pattern was, this is an employee at a manufacturer, and they're alleging COVID. It's a diagnosis, and 6 coworkers got, tested positive for COVID. What do we do? I told them to deny it. You might think that's cold-hearted. You might think that's a losing argument. I don't, because again, the standard is it's the petitioner's burden to prove. Yes, 6 other employees is compelling evidence, right? But so is the fact that this employee might have taken the train to work. He might be living with someone who has COVID. He might be going out in the world in other ways. There's so many ways to catch COVID, as we know. The very fact that it's so transmittable makes it very difficult to prove that it's related to work. So for the most part, I think you're going to have a very difficult time as a claimant proving accident. All right, so this basically just talks about some of the things we just went over, and Again, most of this stuff is now moot. If you'd like a copy of any of this, we'll be happy to send you the PowerPoint. But this is the lawsuit right here. This is the temporary restraining order. The IWCC has not yet put the actual order out reflecting their change from yesterday, and I think there'll be an executive order. And this is the rule that we talked about. Again, very relevant up until yesterday morning, but no longer so relevant. But as you see, it did cover many of the employees that you hire. All right, so I know Jim said you can keep questions till the end. I'm happy to take any questions on this issue because I know it's a lot to absorb. So if you get any questions, feel free to shoot them in the Q&A box. In the meantime, we'll continue. The third big issue, we talked about diagnosis, we talked about accident. Third big issue that you need to be concerned about. Again, even though this rule change is now moot, some of you may have thought, I think we got a couple questions, well, why do I need to worry about this? You do need to worry about it. You will have COVID claims for sure. The pervasiveness of this condition means that you will have claims. I've seen a lot of them so far, and I think it's important for you to know how to deal with them. Obviously, that's why we've got such a great attendance today. So please don't think that because it's now back to status quo that you don't need to be concerned about it. So if your claimant has proven that he or she has COVID and that it arose out of it in the course of their employment, again, I think number two is a very hard burden to prove. But if they do, next issue is causation. Causation is a medical issue, right? People frequently conflate accident and causation because they sound the same. They're both to the idea of, well, can the claimant show or can your employee show that their back condition or their heart attack or their COVID is related to work. But these are two separate issues, two separate burdens for a petitioner to prove, and two separate issues for you to think of. Accident is a legal question. Causation is a medical question. Causation is whether the accident caused their current condition, and the two don't go hand in hand always. You can prove that you've got a compensable accident, that your employment exposed you to a greater risk, but that your current condition isn't at all related to that medically, because you got a prior condition, or because your condition, while related, was temporary and has since resolved. So you need to analyze causation as well, especially with COVID, because we know that COVID hits people with certain comorbidities, certain pre-existing conditions like lung disease, like smoking, like vaping. They hit those people harder. Now, it's true that in Illinois, like in most states, you take your employee as they come. You've all heard of a sort of eggshell plaintiff. If you've got someone who is has a pre-existing condition, but that your employment of them simply aggravates or increases the prior condition, you're still generally on the hook. That being said, there are ways to fight that. We've got great doctors who we use all the time, by the way, very credible, very legitimate doctors who question the relationship between work and certain medical conditions. So I want you to think about causation. And again, maybe the most important thing you can take out of today's webinar is it's always petitioner's burden to prove. Now that the rule's been rescinded, there is no rebuttable presumption. So, you might think, well, this is Illinois. It's a very employee-friendly state when it comes to workers' comp. Very difficult to win these cases. I will tell you that's not true. At the risk of sounding immodest, if you take a look at our newsletter, our website, we have 6 wins, 6 zeros in workers' comp cases that we litigated, that we received the results in 2020. So in 4 short months, we have 6 zeros to prove that you can win these cases. And those issues were everything from causation, accident, permanency. So don't think that causation is a layup for petitioners. It really isn't, especially when it comes to COVID. Final issue on COVID claims that I want you to think of is permanency. That is the bulk of your spend when it comes to workers' compensation claims. That is what costs the most money, because that is what you pay a petitioner for the value of their injury. That's called permanent partial disability. And that is governed by 5 factors in Illinois that determine the value of a case. So, a lot of you, I do a lot of jury trial work, a lot of civil work. Some of you may be familiar with that area. And, when you go to a jury and you ask a jury for damages, you say, my client had a car accident and they had damages of $20,000. Pay my client at least that $20,000 in medical bills, plus another 60 in pain and suffering, plus another 80 in loss of normal life. There are certain ways to calculate damages in a civil case. In comp, there are also ways, there's 5 factors to look at. The good news is those 5 factors don't lend themselves to a lot of exposure when it comes to permanency. Why? Because as you all have heard, generally the symptoms for COVID, if you have symptoms, by the way, we all know that many people who have COVID don't develop any symptoms. If you do, they're generally pretty mild, and they usually dissipate within 14 days. So even if petitioner proves the other elements, diagnosis, causation, accident, when you get to permanency and you decide what this case is really going to cost you, it should be very little, because the long-term permanent, again, it's in the title, permanent effects of this illness, this virus, is very, very low. Of course, if you die from it or you develop brain damage or some liver damage, as we've heard some possible evidence of, those cases have value. But the good news is, for the most part, these COVID cases will have very little permanency value. All right, any questions on that? That's COVID. That's the 4 things you need to worry about with COVID. What about non-COVID issues? You've probably got some workers' compensation cases that aren't COVID that are back cases or carpal tunnel or, operated knees. And how does this affect that? Well, a few things to think about. The most common thing we're seeing is you've got an injured worker, they're off work, or they're working, but they're treating for, let's say, a shoulder injury, and you've accepted it, yet they're not going to the doctor because they're too scared or the doctor won't see them. What do? Do you have to continue paying temporary total disability benefits in that case, which, as probably most of you know, that's 66 2/3 of their salary. Well, before I would write that check, before I would just simply pay TTD for them sitting at home, I would look at things, aggressively and handle it aggressively. We're pretty aggressive in defending these claims because we want to save our clients money, of course. So one thing I would say is send them to another doctor. There are doctors seeing patients. Just because this particular injured worker either doesn't want to or is not, or their doctor is not seeing patients, send them somewhere else. First of all, I wouldn't care if they don't want to. I mean, they have the burden to treat. If they don't treat, then you don't have to pay them benefits. Doctors and medical treatment is outside every stay-at-home order. So don't buy this idea that they can't treat. And again, if the 1 or 2 doctors they've chosen aren't seeing them, send them somewhere else. There's plenty of resources to find great doctors. We can help you. Jim can help you. CAGC can. But find a doctor that'll see them. Second thing is try telemedicine, of course. If that's not really for every single case, but it's a great option. And then you'll see a rise of doctors coming to people's homes to treat them, doing so safely, of course. But I would try all those 3 things before you simply, spend another month, 3 months, 4 months paying TTD for someone not going to the doctor. An independent medical exam, you have the right to get an IME under Section 12 of the Act. You still have that during a pandemic. There's plenty of doctors seeing patients, like I mentioned, even on the expert side. I got an IME report yesterday. It went fine. So, if you need an IME doctor that will see a patient, there's plenty of them out there, and they have to go. If the claimant doesn't go, then you have the right to cut off benefits. Another issue we're seeing is the employer is closed, petitioners on light duty, not at maximum medical improvement. Do you owe them benefits? The answer is yes. Case law in Illinois is such that you can't argue that, well, because of the pandemic, we're closed as an employer, I don't owe benefits. You owe benefits if your employee is on light duty and has failed to reach MMI, unfortunately. All right, just some other quick issues, and then I will turn it back over.
Hey, Rich, I know we're gonna do a Q&A, but I do have a quick question here. I got a bunch that have come through here via registration. So one question I have before we jump into other issues is, can I ask my employees about their families' pre-illness to document their potential outside exposure? So in other words, asking about their family history, etc.
Yeah, that's a great question. The answer is yes, and you should. It's part of your, investigation. They don't. I mean, the real question is not can you ask, is whether they have to answer, right? Because you can ask them anything. Do they have to answer is the tougher one. They don't have to answer because there's no discovery in Illinois. Now, I thought from day one when this rule came aboard that part of the trade-off should have been, okay, there's a rebuttable presumption, give us some discovery. Give us the ability to send interrogatories or even depose petitioner and ask them that very question, Jim. Has any family member been exposed? Has any family member traveled? That's something we have in civil court all the time, right? You would never get to trial without interrogatories. So we should have that ability in comp, but we don't. So you could ask them certainly, and you should as part of your investigation. You should take a recorded statement and ask them those questions. Do they have to answer? No, because there's no discovery. But you should definitely find that out as part of your investigation. Great question. Any others, Jim?
I got another one, and we'll jump to the Q&A in a moment here, but there's some good ones coming through here. Question is, if there's an outbreak on a job site, construction site, and 15 guys get COVID, do you think that's a work comp issue?
Well, certainly it's a work comp issue, if those employees are alleging that their COVID is related to work. You've got other issues. You've got some OSHA issues probably. You've got some other exposure perhaps. We'll talk about, the Walmart case in a moment. But from a pure workers' compensation issue, as I mentioned earlier with my client yesterday, who said, well, I've got 6 other employees who have it. The 7th is alleging they have it. What should I do? Listen, technically, I think you should deny that. If you've got 15 employees and they're all working closely, that is pretty compelling evidence that it's related to work and related to exposure. But again, you need to go through all of your steps and investigate before you simply pay that claim. I would look at their workstations. I would look at the degree to which you're affording them protection. I would look at how much protection they're actually using. If you give them a mask, are they using it? What their breaks are like, what they're doing on their breaks, the actual, what the job involves. The mere fact that other people have it at work is not enough to meet their burden. Do you want to fight that? Do you want to take care of your employees? Those are all, questions that are outside the legal issue. A lot of employers are going to decide, obviously, listen, 15 employees, do I want to be the one employer who goes to the commission and fights that? Or do I want to spend all the money to defend that, even though I think, it's really not that expensive to fight these cases? And the flip side is, if you accept one that's questionable, you're going to have many others. But, there's lots of other issues to look at, but that's a defendable claim for sure, in my opinion, Jim.
All right, I'm going to unmute myself for a second here. All right, Rich, yeah, jump up. I got a bunch more questions, but we can keep on moving through this next slide, which I know is on the new Walmart case, right? And we'll jump into some more Q&A.
Yeah, just some other sort of grab bag issues that we're seeing in the comp arena. All right, the most important one, again, one that got a lot of local and in fact national attention, is a lawsuit that was filed by the estate of a Walmart employee who died, named Tony Evans, Walmart in Evergreen Park here, just a little south of Chicago. And he alleged that Walmart was negligent in failing to warn employees. There was another employee who died, so failed to warn this employee of COVID in the workplace, failed to provide PPEs, failed to clean, failed to do a lot of things. This was filed in the Circuit Court of Cook County, and of course, the reason it got a lot of attention is because I got probably 60 calls in one day saying, "What the hell's going on? How do you sue your employer in circuit court, in civil court for a workers' comp injury? Isn't exclusive remedy a thing?" And it is a thing, and that's those are great questions. The answer is there are exceptions to exclusive remedy. Exclusive remedy means you can only go after your employer for a work-related injury in workers' comp. That's the sort of grand bargain of comp. You can't sue them in civil court where damages are far greater and where you can recover things like punitive damages. The flip side is we as the employer can't blame an employee for their own injury. You can't use comparative fault. This attorney went to circuit court. Now remember, you could file a lawsuit. You could literally, take some crayons and write out the alphabet and file a lawsuit today, as long as you have a few $100. That doesn't mean that that lawsuit is worth the paper it's written on. This complaint is not quite, crayon, but I don't think it'll survive. It doesn't meet the criteria for an exception to exclusive remedy. Without going into the weeds on that, it alleges willful and wanton conduct on behalf of Walmart. Willful and wanton conduct sounds pretty terrible, but it's negligence. It's not an intentional tort. To prove an intentional tort, which is an exception, you'd have to show that Walmart sat there, from a big, glass booth and said, we know that people have COVID who are working here, and let's purposely decide to not correct it. That's crazy, right? Would not happen. So I think this lawsuit will fail. Don't worry so much about being sued in circuit court. If you do, it's, the reason you don't see many of these is because it's really almost impossible to prove the exception. If you want a copy of the complaint,
hey Rich.
I'll send it to you. Yep.
Another question coming in. I'm reading through the registration again here. Do employers have the right to accept or deny?
Well, it depends on your relationship and your contract with your carrier, with your TPA. I think that's what you're getting at. I think the question is it the employer's decision or the TPA or the carrier? That depends on like I said, depends on how your coverage is set up. Many employers have the ability to decide because they have SIRs, they have certain deductibles, but it really depends on your what your setup is. I think, and most of my clients, I've been doing this a while, most of my clients, no matter how big or small, want to have a say in whether to accept or deny. So even if your coverage, even if your policy says, well, it's our decision as your carrier because it's our money. Hell, I'm an employer. I've had workers' comp claims. I, think I've got a lot to, add. So as an employer, any of you listening, I would certainly assert yourself when it comes to any workers' comp claim and make your voice heard, even if technically it's not your decision. Jim will tell you that your carrier, your TPA, your brokers, they're all in business for you. And if they're telling you, I don't care what you think, I'm going to decide because it's my money, probably not the greatest relationship.
Got it. Okay.
So other issues that we're seeing. Yeah, Jim, go ahead.
No, go ahead. I'm sorry. Go ahead. You're right.
No, you jump in. I'd much rather take.
Another question came in. If they don't file a work comp claim, does that open me up more for a civil suit?
Well, no, because again, the only remedy, barring the very slim exception to the exclusive remedy rule, the only remedy that you have as an injured employee against your employer is through the workers' comp system, okay? So it's not like you could decide not to file a comp claim and then suddenly sue your employer for 10 times the damages. That would make no sense because everyone would decide to go, the civil route. The only remedy you have is a comp application. Now, again, there are a couple of exceptions, but they're very hard to prove. So, there's no exposure for an injury by an employee against their employer, but for the workers' comp system.
Great. Sorry for that interjection there. Keep moving, Rich. That was good.
All right. So just some other really quick issues that we're seeing. Work from home issues. I think someone actually asked us in advance. Certainly, we're seeing different type of claims resulting from people who are working from home. Just common sense applies. If you've got someone who's at their desk all day, you want to investigate to the degree that you can, understanding that you don't have the ability to look at video or talk to witnesses, but you want to investigate and see if their accident was more personal, like tripping over a dog than related to work. Subrogation, always with a workers' compensation claim, you want to be aware of subrogation, which means the ability to recover the amount that you paid in workers' compensation benefits from a third party who may be at fault. So while your only remedy generally for a workers' comp injury is against your employer, you can also recover against third parties who may be at fault. So, think of a car accident where your employee sues your employer or his or her employer for workers' compensation benefits. They can also sue the third party who ran into them, who rear-ended them, or you as the employer could do so. So with COVID, we're going to have a whole other range of subrogation possibilities like products liability, against these ventilator companies, or med-mal actions against doctors, especially when doctors are being rushed into practice from medical school, or doctors are coming out of retirement to practice. You can bet that the plaintiff's attorneys are going to be, licking their chops to go after doctors for med-mal issues. Very quickly.
All right, Rich, get another great one for you. Are you ready?
Yeah, I'm
if
ready.
One of my subcontractors or vendors has an outbreak, how does that affect me?
Well, it's probably evidence that your employees were exposed, right? If you've got a subcontractor who can show, your employee would be the one who has to prove that they were exposed to a subcontractor or a vendor who has it, but that would be a piece of evidence in their quiver and, on their end to show that they were exposed. But it's not definitive proof. It's no different than what we talked about earlier with the 15 employees or the 6 employees. It's a piece of evidence. Will that win the case? No, in my opinion. I still think you've got an uphill battle as a claimant to prove that because you were exposed to a vendor, you got it from the vendor versus, all the other possible sources.
Got it.
Now, I don't want you to leave I don't want you to leave this webinar thinking you shouldn't take precautions, right? Obviously you should, and you should take care of your employees. If you've got a vendor or a subcontractor who has it, forget about the law. It would just be, inhumane. It would be immoral. It would be dumb to expose your employees to that risk, right? So, take precautions, avoid this at all costs, take care of your employees. That's all very important. But from a legal perspective, the fact that a vendor or subcontractor has it doesn't, meet the burden.
Okay. We'll go to the next slide.
Yeah, really quickly, commission procedures. The commission's basically shut down for all intents and purposes. So, even in the best of times, a lot of you I know are frustrated with the relative slowness of moving cases through the system. It's far slower now that we can't actually go to court. Much of the success you have in moving a case depends on actually going into court and forcing your opponent to show up in court and getting the judges and arbitrators to buy in. So there are emergency proceedings, but everything's pretty much shut down, which is a problem. And then finally, I had this question yesterday from Business Insurance Magazine. Are we seeing an uptick in claims resolving because people want their money? Yes, to some degree, and we're using that as leverage. Calling opposing counsel saying, listen, money today is even more valuable than it ever was, given the uncertainty of where we are in the future. So take money today. The flip side is, a lot of you know this, cash in hand, cash in the bank is very important. And a lot of my clients are saying, we're in no rush to pay out comp claims because liquidity is important. We'd rather hold on to that money today, just given the tenuous economic times, than pay it out. So yes, I think you should use it as leverage to settle cases, but I also understand the desire to, hold on to some of that cash. All right, so I think we're going to turn, Jim, to our last poll and get people's thoughts on why they hate Illinois workers' comp, if they do. I hear it every day. Again, I want you to take away from this webinar realizing that it's really not that bad. You can win cases here. We do it all the time, and Jim also could tell you the same thing. All right, so Jim, you want to take over here? You're on mute.
Now you got to unmute myself there. My biggest issue with Illinois workers' compensation is it's too costly. Okay. B, too generous to employees. C, takes too long. D, unfair to employers. And E, I think it works pretty well. And so we'll open that up for you folks. We'll give you about 30 seconds and we'll get the results back on that.
Wow.
That's a pretty even response.
Really interesting, huh?
Yep.
So, yeah, I mean, I think the sign of a good poll is that there's not one overwhelming answer. That is pretty consistent with what we hear from most of our clients. All, as you saw, maybe you didn't have a chance to see the poll results, but Jim, yeah, we were, no one got more than 28%. There it is. The biggest one was unfair to employers. And then, some of the other complaints we hear all the time. So you're not alone. We hear that every day from clients, but I hope you take away from the last 60 or so minutes the idea that these claims really aren't as bad as you might think. They're not as expensive as you might think. You can win them, and with some of the tools that we hope we have equipped you with today, hopefully you'll change some of those opinions that you've rendered on that poll. Jim?
Got it. So we'll open it up for Q&A. I know we've asked a bunch of questions that came through registration. If you do have any very specific questions for Rich or I, feel free to put them in the chat box at this time. I do have another registration question that came through, and that was, how will COVID-19 claim affect my mod? And Rich, this might be kind of more on my side of the world, and I know right now nothing's necessarily changed here in Illinois yet, but we have heard the NCCI as potentially looking at this from it may not affect your mod. Now, there's still going to be costs associated with it. So the NCCI, which is the body that determines a lot of this type of stuff in Florida, is looking at this, but it has not been adopted by Illinois by any stretch yet. And we know some states have done that in terms of keeping it separate on the mod per se, but it has not happened yet here in Illinois. So I just want to make everybody aware of that, although that is being talked about as we speak. Any other questions? So, I just want to do a reminder for everybody, this situation is definitely fluid. The rulings change, as Rich mentioned, for the last, 55 minutes. Things have been changing literally by the day, every day. Our entire world is changing. The key is protecting employees. At Gallagher, we have created, as you can see, a pandemic response page packed with resources, not just on the work comp topic, but on everything COVID related, from HR and benefits, what to look for in your contracts, potential coverage issues. The link to that page is in the presentation, which you all get, and you see it on here on this particular page. Certainly feel free to reach out directly if you have any questions on anything we discussed today or insurance related in general. We certainly appreciate your time, and for final words, I'll give it over to Rich Lenkoff at this point.
Yeah, just want to echo what Jim said. These things are changing, and it's challenging to keep up with the changes, but we're committed to doing so. So on our website, you can see literally the up to the minute changes. We'll continue to do so. Our website is bdlfirm.com. And if you've got any questions, feel free to shoot me an email or call me. My info is on the preceding screen, but just Google me, you'll find bdlfirm.com. And I really want to thank CAGC, Jim and Tom and their staff for inviting me. Really enjoyed our discussion this morning.
Yeah, thank you, Tom and staff and the AGC. It's been great, great group to work with. I've been working with the AGC for 25 years now. It's been a long time. Really just amazing. If you guys want to see something really, most of you have probably seen it, but check out the AGC webpage as well. The amount of information on there is really impressive on everything that's been going on for the last 8-9 weeks. Really great resource for everybody. I'd like to thank Rich, outstanding job, and like you said, here's your information's on there. You have any specific questions for Rich, feel free to email him or call him. We thank you for your time, and if you have anything else, certainly you can always contact me as well. So everybody have a great day. It is, I think, 75 degrees and sunny outside, so I would suggest everybody get out for a walk. It's a nice day. So have a great day, everybody.